Thank you, and good morning, one and all. Hearing 10 in relation to biodiversity is now reconvened. This morning we will be hearing from Forest and Bird, Transpower and Federated Farmers. I'm just wondering, as we start the day online, we do have Chelsea McGaw and Shelley Chadwick, Counsel for Council, is online as well, and I see that Mishka Van Hede has also popped up. Is there anything from the planning team that you want to raise before we start hearing from Forest and Bird?
Shelley, no, I don't think so at this stage.
Okay, thank you. So good morning, Chelsea. It's the first time that Forest and Bird have joined us in these hearings, and we have your speaking notes pre-circulated, so feel free to raise the matters that you want, and then we'll have some questions of you, particularly, I guess, some specific matters that have come up through this hearing and others that appreciate some feedback on. So good morning, welcome, and hand over to you.
Morena koutou. I'm just checking you can hear me okay? Perfect. So ko hokanui te monga, ko mataura te awa, no marua wai ahau, ki o te puti o e noho ana, ko o te regional conservation manager ki te rio o te taia, ko McGaw toku whānau, ko Chelsea toku ingoa. My name is Chelsea McGaw. I'm the Otago and Southern Regional Conservation Manager for the Royal Forest and Bird Protection Society of New Zealand Incorporated, which is a bit of a mouthful, so that's why we're more commonly known as Forest and Bird. And today I'm speaking on behalf of Forest and Bird and our Southland volunteer branch in relation to our submission that we put in on the proposed Gore District Plan. Gore is actually where I was brought up. I went to Gore High School and Gore Main School, so it's where much of my whānau where I brought up and where my friends and family still live, and I still visit quite often. So it's a place that I hold close connection to and where I feel that I whakapapa to. So Gore is important to me. So the current Gore District Plan, as you know, became operative in July 2006, meaning it's quite old now and much of the content is outdated and it doesn't reflect some of the newer legislation like the NPSFM and the NPSIB. So the RMA section 75(3) requires that district plans must give effect to any national policy statement, coastal policy statement and regional policy statement. So for a bit of context, New Zealand is in a combined climate and biodiversity crisis. A high proportion of New Zealand's native species are threatened or at risk of extinction, making it one of the countries with the highest extinction rates globally. Between 2012 and 2017, there are population declines recorded for 61 vascular plant species in New Zealand, and some of those plants are key structural species for ecosystems, so their decline can have significant ramifications for their associated ecosystems. The major decline in many Indigenous land-based species, and in some cases their extinction, is largely the result of substantial reduction in the extent and quality of natural habitats, the impact of introduced predators and herbivores on the legacy of past impacts. Indigenous vegetation continues to disappear with land use change and intensification. While rates of loss have slowed in recent times, less than half of Aotearoa New Zealand's land area is now in biodiversity, and Aotearoa remains in Indigenous vegetation cover. It is important to note that the Gore District has suffered high amounts of past ecological loss. There is a high proportion of acutely threatened, chronically threatened and at-risk lands environments where less than 30% of native vegetation cover remains. And there are a limited number of DOC conservation areas, public conservation land and QE2 covenants in the Gore District compared to other districts across the country. So the Gore District supports a range of nationally and regionally threatened species and ecosystems, including rare plant species like the national critical rohutu, nationally threatened hector tree daisy, and the nationally endangered Carex strictissima. And there's also another more of ones that I put in our submission as well, but that's some of the most critical ones. Te Mana o Te Taia, Aotearoa New Zealand's biodiversity strategy, was released in 2020. It is a roadmap which drives conservation action happening at a national, regional and local level to address pressures on nature. It highlights 5 outcomes for biodiversity in New Zealand by 2050, and 2 of the most important ones that I want to mention here are outcome 1, ecosystems from mountaintops to ocean depths are thriving, and outcome 2, Indigenous species and their habitats across Aotearoa New Zealand and beyond are thriving. And the Gore District Council can do its part in achieving these outcomes by providing robust rules, objectives and policies within its district plan to protect biodiversity throughout the district. Since the release of the proposed district plan, the NPSIB has come into force, with councils beginning to implement its requirements, particularly identification of significant natural areas over the past couple of years. These are New Zealand's most important remnants of native habitats, with RMA Section 6 requiring them to be protected. Much of our submission was focused on SNAs, although the government has suspended the need to comply with this NPSIB requirement to identify SNAs. They have not abolished this from the national policy statement completely, so it is still in there and will still need to be done at some point, unless they change the legislation. It is important to mention that the suspension does not change the need for councils to protect areas of national importance under Section 6 of the RMA, as mentioned before. Many councils across the country, including southern councils like some others that I've worked with, like Waitaki, have already identified these areas in their district plans and have a process as part of their resource consent processing to map when they are found through assessments of environmental effects or as part of their own council property and reserves. Closely linked to biodiversity is water quality, with Southland experiencing the greatest losses in water quality, with a net loss of 2,665 hectares of freshwater wetlands between 1996 and 2018. Of the area of freshwater wetlands that have been lost, 98% were because of conversion to land covers associated with farming and forestry. The council can halt any further loss of these important biodiversity areas by controlling activities through the district plan and ensuring adequate setbacks, strong vegetation clearance and earthworks rules, preventing grazing and so on. Although some responsibility for biodiversity and linked issues such as freshwater falls to the regional authority, territorial authorities still have the responsibility to implement the regional policy statement, regional plan, and for integrated management under RMA Section 31, specifically 1B3, the maintenance of Indigenous biological diversity, and 1E, the control of any actual or potential effects of activities in relation to the surface water in rivers and lakes, but also F, any other functions specified in this Act. Being in a combined biodiversity and climate crisis, it is important to recognise that wins for biodiversity also equals wins for climate. These issues cannot be looked at in isolation, and nature-based solutions such as healthy ecosystems can help us mitigate climate change. Biodiversity can do this by enhancing the resilience of ecosystems, allowing them to better adapt to changing environmental conditions like extreme weather events, by providing a wider range of species with different tolerances to temperature fluctuations, and by supporting vital ecosystems like carbon sequestration through healthy vegetation and wetlands, thus regulating the climate naturally. Thank you for your time this morning and for considering Forest and Bird's submission. Kia ora. Are there any questions?
So from the panel, do we have any questions? Glenys? Cliff?
No, I think I'll follow.
Maria?
Kia ora, Chelsea. It's good to hear a voice from Gore, contributing to the process.
I still have my accent despite leaving 15 years ago.
So you've given us a really good sort of overview, a bit of a korowai for why Forest and Bird have entered the process. I guess it would help us to understand if you've had a look at the provisions in the Eco chapter and thought about where Forest and Bird would be looking to see improvement that would support the outcomes that you've just outlined.
Yeah, so in our submission, we did put in some new definitions, like the adding of ecological corridors, for example, and we also some differences to the rules around identifying the SNAs. Just looking through our submission now, things like, only allowing activities if there's no other practicable alternative locations, and we've put in we were asking for livestock grazing within an SNA to become a restricted discretionary activity, not to prevent it completely, but just asking that people would apply for a consent so that they can assess whether that's a habitat which could actually sustain having grazing, because I understand that some areas do better with grazing, but a lot of others don't. So it allows the chance for the council to be able to assess that. So we've made some comments in our submission around some of those things.
If I can just pick up on your ecological corridors, how do we locate them, and what can the district plan do to actually give them what I think you're describing as a degree of protection?
Yeah, I'm not going to say that I'm an ecologist or an absolute expert on it, but what I can say is that it's about looking at things more holistically. So when you get in, a resource consent, you look at what's happening on the neighbouring properties, like if there's a reserve next door or something like that, to maintaining some of the Indigenous vegetation cover, so you can allow an ecological corridor for those species to be able to keep their range and not fragmenting their habitat. And it also, is good for things like lizards and that, because if they have a break in their habitat, it makes them a lot more susceptible to predation and things like that. So there's a whole lot of different ways you can do it. I understand it's a bit harder being a district council to implement ecological corridors, and it is, there's a responsibility on regional council to make some rules around that as well, but there are ways that you can look at when you're processing consents to have a look at what is next door and maintaining some of those areas.
So is that about a matter of discretion, where you've got a restricted discretionary activity and having something in policy so that when a discretionary or non-complying activity comes along, there's some policy support? Is it those two things?
Yeah, and it would be about also, what is it? I'm just thinking of what a specific rule at another council is about, how much impervious surface you're allowed. So if you had more permeability, that might mean that people have more plants rather than, sealing the whole area off. And I realise that they probably don't have to have plants as their permeable stuff, but it allows them the option to be able to do that kind of thing. And we could put it in, resource consent notes to say, we encourage you to do this because it would allow an ecological corridor.
Forest and Bird had a number of submission points asking for buildings to be set back 10 metres from SNA areas. Why 10 metres? Why is a rule like that needed?
So we've based that off a lot of other district plans that and consents that we have commented on in the past. We've just found that 10 metres is a good enough area that it leaves enough for that native habitat to be able to flourish, to be able to spread a bit further, but it's not too close that it begins to impact on them and drive them back. So I'm not sure exactly where the number is from, like research study wise, but that is the requirement that we have been putting on all our other district plan submissions, to have a 10 metre setback from SNAs, because they are significant natural areas. They're not just any kind of, random area that has been identified as having some kind of value. These are significant ones. So it is to allow that buffer to make sure that any activity that's happening beside them doesn't impact on them.
What is your understanding of offsetting?
Well, it's a massive question. I could probably spend an hour talking about offsetting and compensation.
A summary will do.
Yeah, I'll try my best. So, offsetting would be a like for like, offset or compensation of the activity. So say, it is a very hard thing to do. Things like, I've struck resource consents and stuff where they've, removed a wetland, and part of the offsetting package is to create another wetland in a completely different environment and a completely different type of wetland, which to me isn't offsetting. It is the same type of activity, but when you move it into a completely different environment, it doesn't have the same ecological benefit that it would do keeping the original wetland. So I think it's very difficult to be able to actually fully offset an activity and still retain the original value of whatever is lost. But trying to do something that is a similar or very close to the same activity is better than, I've had ones where wetlands have been destroyed and the offsetting package was to do predator control 10 kilometres away. To me, that's not offsetting. So it's doing a similar activity in the similar kind of vicinity to where the effect has happened. So something next door, or, where the same biodiversity or ecology are able to re-establish themselves very close by in a similar environment.
Thank you. We'll take that into account, and looking at the submissions that Forest and Bird have done, we're referred to offsetting. Now, also one of your submissions in this chapter wanted a new policy that seek to minimise carbon emissions in planning, construction, maintenance and ongoing use of the transport network. Sorry, that comes up under one of the other ones, but what can a council actually do in terms of carbon emissions relating to construction, maintenance and use of the transport network?
Yeah, so it's mostly in policies, strategies and policies for reducing carbon. I know Dunedin has done a really good job in a lot of their transport policies. But it is, once again, it's one of those hard ones that council can only control what they can control. But there are small things that add up to, a bigger win across the country. We can't just look at ourselves as one district in isolation. We need to look at, those cumulative effects that us all added up actually contribute. And even though Gore is a small district, there's probably quite a lot of small things that Gore is able to do, like in regards to construction, picking lower impact activities, lower impact ways of doing it, which will be more, and that's more in your, your subdivision policy. I can't remember what it's called, a subdivision, promoting, better ways that people can conduct their activities. And I know that, quite often it's just guidance and you can't put anything in solid rules, but it's good to start somewhere and try and, educate and promote some of the greener ways to be able to do some of these activities.
You've asked for, in addition to Eco Policy 5, relating to what correctly is referred to as commercial forestry activities, seeking a provision that says does not produce any wilding, seedlings or ongoing control must be implemented within a 10k distance of the planting. How does that relate to the national environmental standard that requires an assessment to be done of the possibility of wilding tree spread?
Good question. I actually don't think I can answer that. I'm not too sure myself. A lot of these things we've, plucked out of other submissions that we've made on other district plans. So I'm sorry, I personally don't know the answer to that myself, but I can find out and let you know.
it was more to get context, I guess, in looking at that submission. So we'll just leave that there then. Cliff, you've got a question?
I have to ask this question. How do you reconcile your submission to reduce carbon? I think you're talking about CO2, bearing in mind that CO2 is an essential element for forests and indigenous biodiversity and anything grows. How do you reconcile that submission with that fact?
Oh my God.
That wasn't me, by the way. No, just give me a minute. I need to look at what I put in my submission because I can't remember the exact wording of what I put. So was that under, that wasn't in the eco chapter, right? I've just got my eco chapter one open.
I'll leave that question with you and we can move on. Thank you.
Okay.
Right, any other questions from the panel? Right. Chelsea, there's no other questions. Thank you for coming online. Thank you for your contribution here today.
Thank you so much.
And we'll let you get on with your day. Thank you kindly.
Thank you.
The next person we have coming up online will be from Transpower, I believe. So good morning, Ainsley. Says he. Yes, so you are with us, Ainsley. Good morning and welcome today.
Good morning.
As per usual, we have read through your evidence, so a brief overview and anything else that Rebecca wants to contribute. Look forward to it. Thank you.
Great. Well, thank you. I think I'll break all records for briefness today. Look, Transpower's submission of my evidence is concerned, as you would normally hear from me, about giving effect to the MPS for electricity transmission. But what's a little more unique in relation to ecosystems and indigenous biodiversity is the interplay or lack of with the MPS-IB and the fact that the National Grid is explicitly excluded from those provisions. So my evidence on this topic is usually navigating the way in which that exclusion plays out in provisions. So a lot of my evidence is concerned with that. But I'm in your hands in terms of the level of detail in which I go into my evidence, and that's because I've read the supplementary statement of planning evidence from Mr. Hill and reviewed the amended recommendations, and he has agreed with the outcomes that I support in my evidence, provided some different drafting, but I've reviewed that drafting and I think we're in a position where I entirely agree with the Section 42A report recommendations in that supplementary evidence, such that there are no outstanding matters in my evidence today that I need to speak to. And for that reason, I think, I'm more than happy just to go straight to questions.
We anticipated that it would be a brief presentation from you, and I'll just check whether there's any questions from the panel. Glenys? Maria?
No, in all honesty, I don't have any questions lined up for you. So, yeah, I think you've just given us clear material to work with, and we do understand your position.
And the questions that I had when the supplementary evidence came out took care of them. So, really, Ainsley, yes, the shortest one, but we're here to resolve where there's differences, not to sit down and have a chat where there's agreement. So, if there's nothing else, we'll move on.
Thank you very much. Nothing else from me.
Okay, thank you kindly. Cheers.
Thank you.
Right,
Thank you for
bye.
your time.
So a couple of minutes ahead of schedule, but that allows us to move on with Federated Farmers.
Sorry, Chair, if I could just flag an issue for the Council in respect of the Federated Farmers evidence concerning natural character. I don't know what order Federated Farmers wants to discuss the two topics that they're addressing today, but there is a procedural matter I'd like to raise in respect of Ms. Senizaro's evidence, please, at the appropriate time.
So thank you, Shelley. We'll wait for her to come online and then look at it. We've got so we've got Rachel online and Bernadette here in person. I just want to start off by expressing a bit of concern from the panel in terms of the late lodging of the submission material that's come from Federated Farmers, that with regard to the biodiversity that we received this morning. It does cause us some difficulty in terms of preparing questions and also in terms of absorbing what is being said when it comes in at such a late stage. The panel goes to great lengths to spend a lot of time preparing for these hearings and giving consideration in the way that we pose our questions. So we're disappointed.
Can I let Rachel comment to that? Thank you.
Thank you. Good morning. So I do apologise that it's actually just a hearing statement that I sent through this morning. And in previous hearings, I haven't been sending through the hearing statement. I've just been reading off my computer. But I thought that you would appreciate having those, as that was the method that we took with the SASM hearing. So I'm not introducing any new evidence. I'm just reiterating my points and responding to Mr. Heal's supplementary statement that he put out last week. So yes, I do apologise, and for the next hearing, I think the last one, I'm happy to provide that in advance. It is just quite a tight turnaround from the time that we receive Mr. Heal's supplementary evidence to the time of the hearing as well.
Right, thank you. So in your hands in terms of the presentation today, so you're going to be talking about both ecosystems and also the natural character, because you're unable to be present at the previous hearings, and legal submissions following a little bit later. So how do you want to handle it? We're in your hands.
So Rachel, just to clarify, first of all, we're presenting on ecosystems and Indigenous biodiversity. That's right, isn't it?
Yes, that's correct. And I actually did email this morning requesting that at 10 a.m. the legal submissions are presented. So Bernadette and I, I'm not sure if we'll need the entire 30 minutes, but we'll be 9:30 until 10 o'clock. And then Ms. Cook-Monroe will do her legal submission first on natural character at 10 a.m. And Ms. Senizaro will be online at that time as well.
Okay, so please proceed.
Okay, so thank you for having us here again today, everybody. My name's Bernadette Hunt. I'm a local farmer, Gore District ratepayer, and representative on the Southland Federated Farmers Executive, and have been part of that for approximately 10 years now. I am just going to present just an overarching umbrella comment and then hand over to Rachel. The overarching comment that I just want to make about our position on this chapter is that we have an overriding concern to avoid biodiversity becoming a liability on farms, and perverse outcomes that could arise if that were the case, because farmers want and need to avoid the uncertainty that gets created by heavy regulation around biodiversity. Farmers, for the most part, are very proud of the range of assets they have on their land, including biodiversity, but they have to make a living. And when investment and opportunity is continuously reined in, farmer goodwill can be undermined, and focus can tend to shift from being quite holistic to a narrow focus on working around restrictions. I just wanted to make that overarching comment. I'm mostly here to answer any practical farming related questions. Rachel Thomas, who you've just spoken to, is our Senior Policy Advisor. She is going to take you through the key points of our evidence and answer any questions about that. Thank you. Rachel.
Thanks, Bernadette. So I'll take this opportunity to highlight some of our key points from our evidence. And as I mentioned, I'm not introducing any new information. This is just responding to Mr. Heal's document that was dated 20th of February. So firstly, I wish to identify the matters of which we no longer take concern and agree with the recommendations put forward by Mr. Heal. These are relative to the inclusion of new definitions for animal pest, fire break, vehicle track, dam and walkway, and Eco P10. Federated Farmers expressed concern with the proposed wording of Eco 04 in Mr Hill's Section 42A report, which sought to reframe the enablement of Mahinga Kai, as opposed to the notified version which focused on the restoration of habitats to support Mahinga Kai activities. As such, the recommendation of Mr Hill is now to enable Mahinga Kai. As stated in our evidence at paragraph 55, the enablement of Mahinga Kai is too broad. It should also be considered if the objective needs to include the level of detail which Eco 04 1, 2 and 3 provide. In our view, it would be appropriate for the objective to read Indigenous biodiversity is recognised as taonga to mana whenua, and the relationship of mana whenua and their customs and traditions with Indigenous vegetation and ecosystems is recognised and provided for, full stop. This approach aligns with that of Timaru District Council in their proposed district plan, with the objective stating the relationship of Ngāi Tahu Whānui with Indigenous biodiversity is recognised and provided for. If the panel prefers to maintain the detail within this objective, then further detail on the enablement of Mahinga Kai should be included. Federated Farmers would still prefer that Mahinga Kai is removed from Eco P7, but if the panel wishes to maintain this, then we agree with Mr Hill's recommendation to update the wording to align with Eco 04. Turning to Eco P11, through the Section 42A report, it was recommended that an amendment was made to remove reference to Ngāi Tahu cultural purposes. The proposed wording would replace Eco P11.5 with any offsetting and compensation packages are appropriate, considering the whakapapa, Māori and any Mahinga Kai values of both sites and areas. Federated Farmers expressed concern with the phrase Mahinga Kai values, and following on from the SASM hearing last week, we confirm these concerns remain. Ms Amy Biran, in her supplementary planning evidence dated 12th of February, identifies at paragraph 48 various terminology within the proposed district plan which would cause ambiguity. For example, cultural effects and cultural well-being. We see Mahinga Kai values in a similar manner. While it is clear from the Mana Whenua chapter that Mahinga Kai is a value, within the explanatory paragraph on Mahinga Kai, it does not explicitly state what Mahinga Kai values include. If Mahinga Kai values are included within the plan, the phrase must be appropriately defined within the Mana Whenua chapter. There has been much discussion on Mana Whenua or Ngāi Tahu cultural values within the SASM hearing, and therefore it is important to clarify that Mahinga Kai is a high-level value. The effect of the current wording implies a set of values within a value, which may be confusing to plan users who would expect to see a list of Mahinga Kai values as is provided for other values in the plan, such as Ngāi Tahu cultural values and Mana Whenua values. The addition of Eco P13 has been recommended through the Section 42A report. Federated Farmers supported its inclusion but suggested it be broadened to include the wider district. Mr Hill does not agree, as Eco P13 was designed relative to the bespoke provisions for the Hokonui Hills area. We are in support of these bespoke provisions, and while we would prefer Eco P13 apply across the entire district, we acknowledge Mr Hill's reasoning for it to be restricted to the Hokonui Hills area. Federated Farmers has consistently expressed concern with the permitted clearance limits within Eco R1. We have seen little narrative or justification within any of the supporting documentation regarding why these specific limits have been chosen. For example, we question why the limits are set at 1 metre and 1.5 metres, as opposed to, for example, 2 metres and 2.5 metres. The activities which Eco R1 addresses will be controlled by the nature of each activity. Farmers will not clear more than is required because it is not in their interest to carry out more work than they need to. It would be a waste of their time and resources, such as staff hours and fuel costs. We do not see any need to impose strict permitted clearance limits within Eco R1. In relation to Mr Hill's paragraph 93, we clarify our understanding of Eco R1 and that the widths proposed are in addition to the existing works. However, it may have been overlooked that a greater width may be required where vegetation has become overgrown. An example of this is a vehicle or farm track that has not been used for many years but is now required to be cleared. The track may be narrow and designed for a smaller vehicle, but a larger vehicle, such as a tractor, could now be required for clearance, and this may require initial clearance of greater than 1 metre. Federated Farmers expressed a concern for the health and safety of those carrying out clearance around dams. Mr. Hill, at paragraph 99, suggests that existing tracks could be used for clearance of dams. Dams do not always have an existing track next to them, and if they did, it is unlikely that an existing track would service the entire length of the dam. It may not be appropriate for there to be a track located next to a dam due to the topography, such as hill country or existing land use. With regards to fencing, we maintain our position that no width restriction be imposed. The nature of fencing will naturally limit the clearance associated. A similar argument was made by the Section 42A author for the Earthworks Further Information hearing, and the logic also applies here. Mr. Hill recommends an amendment to Eco R11 at paragraph 101 to specify that the clearance for fencing is no greater in width than originally cleared. In areas where vegetation is overgrown, the initial clearance width will be unknown. For instance, if there has been regrowth or regeneration of vegetation along old fence lines that need replacement, the evidence on the ground of the existing width is likely to be problematic, given there was no past restriction requiring photographic records to be kept. We do not see the width restriction for fencing as implementable and strongly oppose the inclusion in the PDP. Where the permitted activity conditions cannot be met, the cost of applying for a consent for a farmer is largely unknown. In the economic evidence provided by Ms. Natalie Hampson at paragraph 101, the example of non-notified consents amounting to $1,580 and notified consents as $5,000 is provided. These are base level fees and, in our view, significantly downplay the actual costs that would be involved in obtaining consent. These amounts do not consider consultant time for the applicant to prepare an application. In our experience, there are very few applications that get accepted as complete without the input of a consultant. Costs for a simple vegetation clearance consent for a fence may end up costing upwards of $20,000 when considering the engagement of a consultant planner, consultant ecologist, a council processing planner, a council expert ecologist, and runanga if required. We're happy to take questions.
Cliff, any questions? Questions, not statement. No. Linus?
No questions, thank you.
Maria?
Kia ora. So I had a sort of a realisation when you were talking about the Mahinga Kai values, and what I realised when you were speaking was when you said, is this a value subset of the value set? What I recognise is you're drawing attention to the fact that in this chapter there's only one instance where that phrase is used, Mahinga Kai values. Otherwise it's just the term Mahinga Kai. So if I'm understanding you correctly on that point, where just the term Mahinga Kai is used, that's not causing you consternation. It's where the phrase Mahinga Kai values is used, and that's only used once in Eco P11 in the supplementary evidence of Mr. Hill. Have I got that right?
Yes, that's correct. So I think I did a quick search on the entire plan, and Mahinga Kai values is in there 5 times, I believe. However, with all of the discussion around values and where they'll be located in the plan, I just think it would be good to either clarify specifically what Mahinga Kai values within the Mahinga Kai value are, or remove the phrase Mahinga Kai values, because it does imply a separate subset, which doesn't exist.
So I'm following you in terms of that's exactly the kind of thing that the wrap-up hearing is set to do. But where it occurs at the moment in the recommendations of Mr. Hill is in Eco P11 and the reworded 5. So if it said instead any offsetting and compensation packages are appropriate considering Mahinga Kai not Mahinga Kai, Ngāi Tahu cultural values, which is the phrase that's being, or whatever the phrase is that is landed on for the plan as a whole, and if that phrase is Ngāi Tahu cultural values of sites and areas, and then you had the including whakapapa, Māori and Mahinga Kai. So so this is one of those examples where that broader phrase, Ngāi Tahu cultural values, can be given specificity, which is, I think, what is attempted to be done here, like to include whakapapa, Māori and Mahinga Kai as the specific things to be considering within the, broader bucket of Ngāi Tahu cultural values. Is that sitting right for you, that thinking? That it's trying to provide specificity?
I fully appreciate how you're trying to link it back in terms of consistency with the rest of the plan. I think that's a good approach, but my concern would be then that Eco P11 is opened up to the rest of the Ngāi Tahu cultural values. And our preference is that the specific values are specified where possible. So I think P11 does a good job at specifying the values, and that approach perhaps could be reflected throughout the rest of the plan.
Okay, so you've given us something to work with in terms of thinking about how it's resolved across the plan, and particularly in this chapter. Yep.
What is your understanding in terms of the number of properties that are affected by the rules for Indigenous biodiversity?
Did you want to answer that, Rachel? Or?
Oh, yeah, I'm here for you too, Bernadette, if you'd like to.
So, look, we haven't surveyed and done, but what we understand is that actually many people probably don't know. So what we haven't done is done a survey to get a number. So I can't give you that number, but we also know that, or our understanding is that the rules will capture more than people realise, and we don't want to cause alert or alarm unnecessarily until we know how this lands. But we can't give you a number. So
I'll go to our team opposite in terms of, I think, Natalie, it was you who listed the numbers.
On 77.
Yeah, but the breakdown in both categories.
Yes, so there was, we have done a GIS analysis which looked at where the Indigenous biodiversity, where that was mapped and how that related to property boundaries in the general rural zone. There are 115 rural properties that are privately owned that contain either an EVA or a SEVA. That's 77 that contain a SEVA and 68 that contain an EVA, if I've got those around the right way. So it's a very small number of properties that contain any Indigenous vegetation. And further, the assessment has looked at the coverage of that relative to the size of those properties, and a significant majority of that coverage is very, very low, less than 10%. And there's only a few properties that have coverage of greater than 10%. So it's in my evidence that this is actually affecting a small number of properties, and the likelihood of fencing and other farming activities actually needing to traverse through those Indigenous vegetation areas is fairly minimal on a day-to-day basis. So that has been covered in evidence.
Mm-hmm.
So I guess one way of looking at it is, are you overstating the impact that this is going to have on the farming sector?
Rachel, do you want to talk to that first?
Yeah, I'm happy to. We Federated Farmers represents all members, so we're trying to get the best outcome for all of our members across the district. And 115 sites, I think we refer to that within paragraph 92 of our evidence, but we're aware of the extent of it. But once you set the framework, though, there could be further sites identified, because I understand that while there's been government direction not to map any further sites, that work still is going to continue by the council and will sit outside of the plan. So that 115 sites is an initial indication, I guess, but there could be more. And also there is the possibility that consents could cost $20,000. So if we are trying to improve the rules so that they benefit the one farmer who's going to have to pay $20,000 for a consent, then to me that's effort well spent on our part.
Well, I think the second part of what was described was that the proportion of properties that are actually identified through the mapping that has been done is relatively small, and in many cases, I guess, bordering on not significant. So isn't the effect of the rules to actually encourage farmers to use the grasslands that are all readily available rather than reducing the areas of indigenous vegetation?
I would suggest that it may not be significant in the broad scale of the region, but it's very significant for those farmers affected that have invested in land and potentially invested in that biodiversity and then are looking at how they may see it being penalised for that. So I don't think it actually matters how small the numbers are. It's important that those farmers' livelihoods protected, and also that they are not penalised for having stuff we should all be proud of on their farms.
Just changing tact, reference was made by Rachel to dams, and I'm just wondering how many dams and what sort of form they take on farms in the Gore district. When I think of dams, I think of concrete structures at one end of the scale, and withholding of, I guess, duck ponds at the other end of the scale. So what sort of dams do we have in the district, and what sort of frequency are we talking about?
Yeah, look, again, we don't have specific numbers on this, and again, and water storage is not a massive thing, obviously, in this district, but there will undoubtedly be some dams on farms that could be for a range of purposes, small amounts of power generation, duck ponds, as you say, things like that, but in all of those cases, even if the numbers are small, do we really want to force people into a 1 to 1.5 metre strip around the immediate outside of the dam to do any maintenance or repair work? I don't see the value of a rule like that.
I guess as well, you're critical of the standards for allowing clearance each side of tracks and fences, etc., at the metre 1.5, and relating it then saying why not 2.5? Is it that you're not wanting to have a number specified at all?
Yeah, I think the 2 and 2.5 is literally just an example. When you think about the practicalities of trying to maintain a fence, most of the time these days that involves a tractor, and often these things aren't done on flat, safe land. So if you think about the logistics of navigating a tractor alongside a fence, having to back it up to the fence line to push a post in, and then drive it out again and drive it to the next location, trying to do that in 1 metre or 1.5 metres or 2 or 2.5. Actually, what farmers need to be able to do is be safe when they're doing activities like that, and penning them into a restricted area doesn't allow them to make the best decision to pick the appropriate path that makes sense for them. And as Rachel said, there's no logic for a farmer to clear land that they don't need to clear. It's expensive, time-consuming, difficult. So it's what's the practicality, what's the purpose, and what's it actually going to achieve.
Okay, so the impression I get from that reply is that you think that each side of the fence you're only allowed 1 metre, 1.5 metres. Is that right?
Rachel can clarify that. I'm not sure the detail. Sorry.
No, I believe the updated wording from Mr. Hill is no greater than existing width already cleared, which is problematic if you've had vegetation regrow. I don't see how there's any way that you would know what had initially been cleared.
So what I might do is go back to Matt and pose the question, how do you know what is originally cleared?
So as I understand it, you'd have to look at old aerial photography, etc., in order to determine that. I think might have some more comments in terms of the memo that was circulated yesterday, Mr. Wells.
Yeah, so again, I'm not sure if you've seen the memo.
Rachel may have.
I did a quick summary of farms which Environment Southland has surveyed in the Gore district to have a general look at where fences run on those farms around Indigenous vegetation. And on those 13 properties that I looked at, there wasn't an example where a fence actually went through Indigenous vegetation areas. On those properties, all the fences were actually had at least one side of the fence adjoining improved pasture. And then in most instances, most instances, the fences actually had improved pasture on both sides. So if that was looking at the rest of the areas where there was SEVA or EVA in the lowland parts of Gore, it seemed that was fairly representative. Again, totally agree that it won't be 100%, I would doubt, but it did seem quite a reasonable representation of the likely scenario where you've at least got, if you do have Indigenous vegetation, it seemed that the fences were along the boundaries, often because the Indigenous vegetation was in difficult country, gullies or steeper hillsides. Obviously that definitely doesn't apply to stations like Wantwood, Stony Creek, I suspect the Mount Wendon area, where I think there would potentially be a very different scenario.
So could I pose the alternative suggestion then? If it's such a small number, and in most cases isn't going to be required, why have a restrictive rule that makes it difficult in the small number of instances where it would be necessary?
And this is where I'm going to ask a question, because we're bound by the law in terms of our decision. And the law on this, which was discussed yesterday in terms of the MPS IB direction, is that existing activities continue to the scale, extent and intensity and location of existing activity, and that is the legal test for carry on as you go, no resource consent required. So whatever we put in the plan has to reflect that national direction. And the places obviously that we need to look to guide our decision are the operative MPSIB and the operative RPS. They're going to tell us how to handle this. And that idea of existing scale, extent, intensity, location is what's guiding the idea that, thinking about maintaining something that's already there, like a fence. So one of the reasons I think that Mr. Hill is introducing this language around that he has introduced Eco R1 is recognising that Eco R1 at the point of notification was probably more restrictive than the MPS test, but the MPS test is the one that we have to apply. Okay. So same scale, extent, intensity and location. Yeah, so that's what we need to reflect. And the idea is that to not enable a new scale or extent, and as soon as you're getting to new scale or extent, that's when resource consent is required. So we're hearing the practical considerations that you're bringing to the table, and this is my way of saying that we've got legal implications that we need to adhere to, and that's the intersect going on here.
Cool.
Yep.
Can I give an example that may just help with why I'm and this is a real example that we had on our farm a few years ago. We wanted to plant some vegetation along a fence line, both for visible protection and some shelter. We didn't want to plant a high thick tree line. We wanted kind of smattered cover to give some shelter, but not actually encroach on growth on the other side of the fence. So there is pasture on the other side of the fence. We chose along that tree line, along that fence line, to plant natives. So a range of different species along that fence line, spaced about 2 metres apart, all the way along a very, very long fence line. What I'm concerned about is, in terms of practicalities of maintenance in the future, we're better off planting non-native species. That's what I'm trying to avoid. I want us to be motivated to plant those Indigenous species.
So agree that's important. That would go to the ecological corridor idea that was put on the table before by Forest and Bird. So, but the scenario that you just described would not fall foul of these rules. You would be fine to do that and not fall foul of these rules.
What about in 20 years when I need to maintain the fence?
Yeah, it's quite explicit of
Okay.
excluding vegetation that is deliberately planted for
Great,
that
sorry,
type
my
of
understanding.
purpose. Yeah.
Okay. Rachel, is there anything else you wanted to add?
I guess it's difficult for us to consider how there can be such strict with restrictions for fencing in the rest of the zone when obviously there's been a relaxation on that particular requirement for the Hokonui Hills area, which contains the majority of CEVAs and SNAs. So from our perspective, it's low risk that there's actually going to be any further loss of Indigenous biodiversity in response from farmers being allowed to fence with no width clearance in the rest of the district.
There's a difference between allowed to fence. So I think what we want to be really, really clear in is the difference between new activity and existing. Yeah. So what you're meaning is allowed to maintain an existing fence. I would expect.
Yes.
Yeah.
Yes.
And so what you've highlighted is that we need to pay attention to application of the law in the Hokonui Hills and consistency between the way that we apply the law there and the way that we apply the law in other parts of the district. Is that a fair way to categorise that?
We're in full support of the work that has gone on in the Hokonui Hills and think that the council's done a great job working with Stony Creek on that working group. Our view is that if the majority of the SNAs are in that area, then it's low risk to permit any type of any work on the existing fences in the rest of the area of the district. So, yeah, it's no. I fully agree that there shouldn't be any provisions that restrict fencing within the Hokonui Hills area. I just think that they should be applied more widely throughout the district as well.
So, in our discussions yesterday, questions were being asked and answered and are still a little bit outstanding in terms of the relationship between the law and the Hokonui Hills proposal. So we're still working through that. No decisions have been made, obviously, until they are made. So the key thing there was Doc putting on the table that the test is this area of habitat or this species significant, and that's the starting point for pretty much everything that we do after that. Yeah, so that's just context, and that would apply. That significance test in the law is agnostic about where we apply that in the district. It's if identification shows there is a significant habitat or a significant species, there is an expected policy response. Yeah.
Bernadette, have you ever seen a fence repaired or put in within a margin of 1.5 metres with an agricultural machine, a tractor, or a post driver on the back of it?
No, and probably not even with a quad bike and a human doing it with a trailer carrying the posts and the like, to be fair.
Amazing. Surely, is there a bureaucrat anywhere that would actually come out and be able to achieve that? Seeing as a farmer, you don't believe it can be done?
I wouldn't think so.
I'm amazed.
Okay. Anything else on the ecological and ecosystems and natural biodiversity? Maria?
No, it's always important to have the practical perspective. Kia ora.
Thank you. So we have online the necessary people to talk about the other issue in terms of the natural character. One more question.
One more question. Would you consider you're an expert witness, you know, in respect of farming practice, which includes fencing?
I'm not sure what that means.
Or you enthusiastic amateur? I mean,
I'm a farmer. I'm not sure what your question means, Mr. Bowden.
Okay.
I want to know how much weight I should be attaching to your opinion as a farmer. Do you know what you're doing, or should I be asking somebody off the street?
I'm a practicing farmer. I'm
Right.
not.
Would you consider yourself an expert?
Yeah, well, the way you define an expert can differ, and that's something we need to talk about.
Yeah. Still like that person's opinion. Thank you.
Okay. All right. So we have online the necessary people to talk about the natural character. Joanne, I think you're intending to lead off on this. So in your hands.
Thank you very much for having us in front of you again. What I propose is just to do a summary of the legal submissions that you have in front of you, rather than step you through paragraph by paragraph, if that is okay. These legal submissions are made on behalf of Federated Farmers New Zealand, the Southland Province. With me today, we have Miss Kate Sanazaro, who is our Senior Policy Advisor / Planner, and she is our planning expert today. I note that there was a request by the panel to the Council, based on the Section 42 report for natural features and landscapes, to prepare a draft natural character chapter. In summary, Federated Farmers does not believe that the Council has scope to introduce a new natural character chapter into the proposed district plan. We respectively request that the proposed natural character chapter should not be progressed any further, and that the current provisions related to natural character in the proposed district plan should be relied upon. If the panel still wishes to pursue a natural character chapter, we request that a variation to the proposed district plan occurs so that engagement can occur under the Schedule 1 RMA process. We do understand that the hearings panel can only recommend that this occurs to the Council, and we accept that limitation. If a natural character chapter is pursued, Federated Farmers in the Southland Province would like to be involved in the development of any natural character chapter as an affected stakeholder. I note from the Section 42A report that 3 submissions were relied upon for scope to do this. The first was the Southland District Council submission, and I note that that submission sought no direct relief. It mentions a natural character chapter, but does not ask for one to be introduced into the proposed district plan. The council submission was written in very passive language with no action being asked for. As a council, it works with the RMA on a regular basis. It is one of the main pieces of legislation that the council works with. The submitter essentially should have known better and have actually asked for direct relief, as that is standard practice in an RMA policy plan submission process. We do not believe that the Southland District Council should be relying on the hearings panel to read something into their submissions that wasn't asked for. The second submitter that has been relied upon was the New Zealand Transport Agency. We note that their submissions were quite specific to certain areas, and that they did not directly or indirectly ask for a natural character chapter to be introduced into the proposed district plan. The last submission relied upon was the Alliance Group. Again, they did not directly ask for a new natural character chapter, and they sought clarification on certain areas that affected
their property that they had. I do not propose to run through the case law and legal scope. Again, I am sure that the hearings panel and the council's legal counsel is very familiar with the legal scope case law and what is required. But just to note that there is a two-limb test to be satisfied when deciding whether or not a submission is on a plan change. A, it must address the proposed plan change, and B, the council must consider whether there is a real risk that any person who may be directly affected by the decision sought has been denied an effective opportunity to respond. We believe that the panel does not have the scope to introduce a new chapter. No submitter directly requested a new natural character chapter, and we believe that it would be procedurally unfair for a new chapter to be introduced into the proposed district plan at this time. The proposed amendments we consider alter the structure of the PDP, introduces new information, both the chapter objectives and policies, and has occurred after the further submission process has closed. We consider there's a real risk that people who did not originally submit, as they were happy with the proposed district plan as notified, may or would have submitted if a separate natural character chapter had been present in the notified PDP. We consider this situation as the reverse of what has happened with the SASMS chapter. Council did not consider that it was relevant to notify the proposed district plan with a natural character chapter. No submitter has asked for a natural character chapter to be included, but the council is looking to introduce the chapter after submission process has closed without having the scope to do so. Very short and to the point legal submissions today.
Thank you. I understand that the council's legal counsel, Shelley Chadwick, who's online, wanted to also raise some issues with regard to the submission from Federated Farmers on this point. So it's probably appropriate we hear from Shelley and Joanne give you an opportunity to respond before we move to Kate and her evidence. So Shelley, thank you.
Thank you, Commissioner Hoover. So the issue I wanted to raise is a procedural one. The reference I'd like to make initially is to minute 31, which recorded the process for preparing for the natural character hearing. So in the directed dates in preparation for hearing stream 9, submitters' evidence on natural character was due to be filed by 27 January 2025. Legal submissions on behalf of submitters in respect of natural character were due to be filed by 4 February 2025. What has happened is we have received legal submissions from Federated Farmers on the scope issue, which Ms Cook-Munro has just spoken to on Friday, so the 21st, I think it was. We also received a further brief of evidence from Federated Farmers seeking to make further comment in respect of natural character on Friday. So that's Ms Senazaro's brief. I am happy to speak to the legal submissions we received on Friday. I note that Ms Thomas raised issues which have been broadened somewhat in Ms Cook-Munro's submissions, and I'm happy to speak to those today. I don't have a concern about that. What I do have a significant concern about is Ms Senazaro's brief, which comes in, as I say, effectively a month late. Ms Ben-Heedy has been on leave for the period of time since the hearing and has had no opportunity whatsoever to pick up this evidence. She has attended today in order to hear Ms Thomas's comments on the brief that she had already filed. She has not had an opportunity to prepare for or be ready to respond to a new brief. But beyond even just the council's ability to respond to this new information, I would note that any party who had been following the process for the natural character topic has no knowledge of this new brief. It might have been put up on the website for this hearing but it wasn't put up on the website for the natural character hearing stream 9. So any other submitters interested in natural character had no information at all about this new brief of evidence, which they would, looking at minute 31, have expected had to have been filed by 27 January. So I need to place this concern for the panel as a significant procedural concern. My learned friend just spoke to a process being closed, and in my submission, the process for providing submitters evidence was closed on the 27th of January. So I would ask the panel to consider making a decision on whether to accept Ms. Senizaro's evidence. And if you're not in a position perhaps today to just make a decision on that, then perhaps the evidence could be taken with a note that a decision will need to be made on this procedural concern before it's considered in terms of your substantive decisions.
Is a potential response to the procedural concern that you've raised an opportunity for all other parties on the chapter to have comment on this, particularly also the council?
I agree that's a potential option, and certainly if you do want to take account of Ms. Senizaro's evidence, even on a provisional basis today, we would seek an opportunity for Ms. Banhidi to make written comments. As I say, she hasn't had the time to look at it and consider it. So that is something that would be appreciated. I do note, though, that this process has already been underway with a minute and then a further hearing. So there is a point at which the panel will need to consider whether what has been provided is of a sufficient assistance or a sufficient issue that it makes a call on whether it wants to pursue it or not.
Okay, thank you for that. What I propose is that we do hear the evidence today, and we'll make a ruling on what you've raised in due course. I guess part of the reason why Federated Farmers are here today addressing this is that at the hearing that we had for natural features, we expressed disappointment that Federated Farmers weren't in attendance or had submitted anything, and we did have some questions of them. So I guess the issue that has been raised is in relation to the depth of what is now in front of us, and we will deal with that in due course. I don't know, Joanne, whether there's anything you want to add?
My understanding is that the evidence to be presented by Ms. Sanizaro is in response to the comment that was made by the panel. I acknowledge that, yes, it is past the time that was set for the evidence to be lodged, and I reiterate what my learned colleague has said. It will be up to the panel to decide how much weighting is given to that evidence. I just urge the panel to hear the evidence with an open mind, as it was designed to assist rather than hinder.
Thank you for that. So we'll move on to Kate then. We have had a read through it, so a overall introduction would be appreciated. Thank you.
Kia ora, good morning, Mr. Chair and Commissioners, and thank you for inviting me here today to hear my evidence. And just as a point of clarification, I submitted my evidence on time on the 27th of January. I was unable to make the hearing for natural character, which I believe was about the 11th or the 12th of February, and subsequently I have been asked to attend at this hearing and answer any questions that the panel may have. In terms of what I submitted on Friday, that was merely a written statement, which I was intending to talk to today, rather than additional evidence per se.
Thank you for that explanation. Please proceed.
So just in terms of what you would like me to do from this point, please just let me know.
Well, if you give us an overview of what is in the evidence, and then we'll come back with some questions.
Wonderful. Right, so I was asked to take a look at the natural character provisions of the of this proposed new chapter, and also at how the notified proposed district plan dealt with natural character. And two things came to mind, and one was whether you had scope to do so on the basis of submissions, which Joanne has touched on, so I won't go in further into scope. But the other question that I had was if the intent was to create a standalone natural character chapter that reflected what is effectively in the notified plan, and subject to any other adjustments that might come about as a result of this process, that the proposed draft chapter, as drafted, did not achieve that, and that concerned me. And I just think, and in my professional opinion as a planner, that the development of an entirely new standalone chapter on the basis of submissions where that content is has a wider effect than the plan provisions as notified, and members of the public aren't provided the opportunity to submit, that's not good planning practice. It would be my preference that the council use the current plan structure and provisions, and if they feel strongly that a natural character requires a greater focus within the plan, that they give full consideration to the perceived problem that they're trying to address and undertake further engagement, consultation and development in doing that. The alternative relief that I seek is that the council makes those changes to address my concerns and pulls back in the content of the proposed natural character chapter to reflect the framework that is in the proposed district plan. So I have provided that commentary and detail within my evidence.
Right.
Regarding individual submissions.
Yeah. So
but
can
effectively,
can
sorry.
I just so two things. A detailed analysis that you've provided us is probably a bit more than a normal hearing statement. That's detailed analysis and evidence, so that's one thing. But what I wanted to check in with you at this point was the response to the National Planning Standards, because that's the point that's raised in the Southland District Council submission, and that's the point that we're responding to. So I'm going to read it out. If provisions to protect the natural character of wetlands, lakes and rivers and their margins are addressed, they must be located in the natural character chapter. What is your response to that?
I don't have their original submission in front of me, but if it did say must, that's not necessarily my reflection. I might have said should, but I'm not here to.
Sorry, that was me quoting the National Planning Standards. Yeah. So the National Planning Standards say that.
So in terms of the National Planning Standards, they provide a layout, a framework that must be followed, and some of those chapters are mandatory and some are not. And natural character is not a mandatory chapter that you must have, and the council can choose whether it includes a standalone chapter or not.
Stop there. Hang on. I'm just going to read it out for you again, just so you can hear it, and I need to do this before you go any further. Okay. So what you've just said is quite correct. There are some mandatory chapters in the National Planning Standards, and there are some optional chapters. Now, those optional chapters usually start with a preface string, and the preface string goes like this. If provisions to protect the natural character of wetlands, lakes and rivers and their margins are addressed, they must be located in the natural character chapter. So it's just to orient you in terms of this isn't necessarily coming from the idea that the panel's decided that this needs to happen. It's a response to giving effect to the National Planning Standards, and that there is a submission that pointed us to say, hey, you need to give effect to the National Planning Standards. So that's the starting point. And so you can continue now if you'd like, but it's just recognising, yes, it's not a mandatory chapter, but it does have an entry string that says if you are doing this, then you must. And so The second part of what you're saying is that when we go to do that, we shouldn't go beyond the extent of the effect of what was notified when we do that. That's the second part of your position, yes?
Yes.
So my question then is, what is the effect that is different in what is in the proposed chapter to what is in the existing plan or notified plan?
So for example, policy NFLP1 seeks to avoid adverse effects on the values and characteristics of outstanding. Sorry, I've got the wrong chapter open. Oh, that's the NFL chapter. Apologies. But I believe there is an avoid policy in there, and avoid policies typically lead to prohibitions, of which there is no prohibition in the plan. Avoid policies are very strong policies, and I don't feel that the PDP is notified reflects any prohibitions or the need to avoid adverse effects.
So
there's certainly a consideration.
So we then need to do the other bit of this, which is respond to Section 6A of the law. So Section 6A is different in what it's trying to achieve compared with Section 6B, but it does have a similar pattern in the second part of Section 6A, which says protect from inappropriate subdivision use and development, and that is a mirror of that same phrase in Section 6B. So in terms of giving effect to both the National Planning Standards and Section 6, can you comment on the relationship of what you just said with Section 6A and particularly the back end of Section 6A of the RMA?
Yes, so I think another concern I have with the plan, and acknowledging what Section 6A says, but it is to protect them from inappropriate subdivision use and development, not all subdivision use and development. And I think that's really important. And I also think it's important to note that the council is quite welcome to have a natural character chapter if that is indeed what they feel is necessary in order to meet Section 6 and how they would like to manage rivers, water bodies and their margins. However, I'm raising concerns with the process around it and the robustness of the process to ensure that that the issue is really thought about and not responded to in an ad hoc, cut and paste manner, and that that the public get to have a say on that and test out those provisions.
The upshot of that would be the effect and extent of that effect in terms of outcomes for a plan user compared to the point of notification. That's the test that you would be looking to have met to fit within scope.
Oh, sorry, could you please repeat that?
So I think what you're putting to us is that scope relates to the effect of provisions in the plan at the time of notification.
Yes.
And similar to the conversation that we had the other day on scope in the SESM hearing, we've got the scope of the plan at the point of notification plus submissions and evidence in the hearing, and those things all together provide the extent of our place to move. So it's not just the plan at notification, it's the plan at notification plus submissions plus evidence that we need to bring into the mix to And that's the bounds of our scope, the combination of those three.
Was there a question there?
Yes, I'm asking if you agree that it's not just the extent of the plan at the time of notification, it is that, but it's that plus submissions plus evidence that provides the bounds of scope.
Yes, and insofar as a reasonable person might anticipate some of these changes that would come through from submissions.
So let me put it another way. Are you suggesting that the submission point of Southland District Council that said you should give effect to the National Planning Standards when it says this, that you're suggesting we give little or no weight to that submission?
I believe you should consider the submission in terms of the weighting. That is your choice. However, I think you need to have in mind what natural justice and careful consideration of the issue at hand, and just allowing people to have a reasonable say on an entirely new chapter.
So a number of the provisions, including what is now shown as Appendix 6 and what's been promoted, come out of the Natural Features and Landscape chapter and what is currently Appendix 5 in the plan. So in terms of the structure of what was there as notified, what would be your expectation of changes without, if we accepted your view that there shouldn't be a new chapter, what would be your expectation in terms of the scope of changes made within the existing Natural Features and Landscape chapter, and any change to the wordings in what is presently Appendix 5?
So with regard to Appendix 6 specifically?
Well, Appendix 6 comes from the current notified Appendix 5. So what would be your expectation both with Appendix 5 and the Natural Features and Landscape chapter? What is your expectation in terms of the scope that we have to make changes to those provisions based on the submissions received?
I think Joe Cook-Monroe has covered that off in our legal submission, is that our position is that we don't believe you do have scope to do such a change. And my reading of Appendix 6 is the Mataura River description came from Appendix 5, but I'm not certain that the natural character values that have been included were originally in Appendix 5, but I stand to be corrected on that.
Yeah, maybe I wasn't clear enough. Putting aside the issue of scope, so if we accept your issue of scope, we go back to what is in the plan as notified. What would be your expectation as to the scope we have to amend the natural features, natural landscapes and features chapter and Appendix 5, the way that it was notified based on the submissions? What scope do you believe we have to change?
In terms of the natural features and landscapes character, I have not been all over that. I obviously looked at it in relation to the natural character provisions, but I haven't otherwise been involved within that character and with the submissions on that character. Sorry, landscapes and features. I think insofar as natural character and landscape address a similar issue, then there is an affinity to have it sitting within that chapter. but I do feel that pulling out natural character into its own chapter and creating an objective and policies that stand alone does have a fundamentally different effect on how natural character might be considered by users of the plan.
So if what is in the draft chapter for natural character was all put back into the chapter for natural features and landscape, would that meet your concerns?
Do you mean then you're saying to just leave the natural features and landscape characters untouched with its, I believe it mentions natural character in there, in one of the policies, if memory serves me correctly.
Well,
So no, I wouldn't have any concerns with that.
yeah, maybe what I'm suggesting goes a bit further than what you've just described. We've had recommendations made to us as to the scope of changes that are appropriate to make, and then they've all been taken off and put into a new chapter. But if we left them all with the changes that have been recommended to us in the natural character, in the landscape and chapter, and those changes in the existing notified one plus the submissions stay in that, plus the recommended changes in response to submissions stay in that chapter. Are you comfortable with that?
Yes.
Okay.
I would be more comfortable with that.
Okay, thank you. Are there any other questions from the panel? All right, there's no further questions, so thank you to all those who are online. Mishka, if there's anything further that we need from you, we will come back to you, and taking into consideration what's been raised by legal counsel. We will do our best to address that this week.
Sorry, Chair, can I also just point out I've got some legal submissions to respond to Fed Farmers legal submissions. I don't need to give them now. I can give them in writing. I'm totally in your hands what's best for you in terms of this hearing process.
Yeah, I believe it would be good to hear them now, and I think out of natural justice, I think there should be an opportunity to respond if Fed Farmers are of that view. So,
with all due respect, I'm currently in a court mediation, and so actually having written submissions from my learned colleague
I'm sorry, I don't accept that's relevant. I mean, this is the hearing. When we're hearing them, you don't have an opportunity for reply anyway. So if the panel has the benefit of hearing the submissions concurrently, I think that would be appropriate in this instance.
Okay, and you would still send around a written copy?
Certainly can provide a synopsis.
Yes, appreciated.
But that won't be an opportunity for further comment. It's just as per all parties in the hearing, the evidence in this hearing will be on the website.
Yes, appreciated.
Okay, thank you. So, yes. Over to Shelley. Thank you, Shelley.
Thank you. I'll be as quick as I can. So, my first point is a general one. Really, I just am a little bit unsure why Southland Federated Farmers keep attending these hearings and keep seeking that particular chapters be withdrawn and a new process commenced. The evidence has consistently shown that Fed Farmers has been involved in consultation processes and myriad public processes for the proposed plan over the past 5 years. They've also been closely involved in the Schedule 1 process, including their original 115-page submission, including briefs of evidence for now 10 hearings on this PDP, including attending each of those hearings to date. In my submission, this is a public process which has provided for adequate comment, discussion and promotion of a position by Southland Federated Farmers, and there is no basis for the panel to decide that so many of these chapters they are asking to be withdrawn should be withdrawn. Submit overall that their request again on this chapter in that nature should be rejected. In my submission, the panel has full scope to incorporate the provisions under consideration following minute 18 and hearing 9. I'm turning to my reasons for saying so. I would start by noting, although Commissioner Bartlett's made this point this morning, scope considerations begin with what was in the notified plan. So that sets the original limits in terms of what the panel is considering that it may move forward with. What then occurs, as you're well aware, is that the submissions can extend that bucket, for want of a better word, of what you are considering to take forward. So starting with the notified provisions, that can be expanded in a particular way by the submissions received. That bucket contains the ideas, the tools, the comments from the notified plan and from submissions. And in my submission, the ideas and the tools in the natural character chapter are fully within the original bucket of the notified plan and the submissions. I would submit that the submission by Southland District Council in combination with the notified plan provisions provide a strong and fully foreseeable link to what has been prepared for your consideration in response to minute 18. I would also submit that Southland Federated Farmers has failed to recognise the link between the submission received and the National Planning Standards, which again Commissioner Bartlett has identified in a question for the witness. Finally, I'd just actually like to specifically refer to the summary of submissions that was prepared, and that is the summary of submissions document. I'm looking at the particular one, the summary by submitter, submitters starting with S, and that includes in that table the summary of Southland District Council submissions. Now, the summary of submission document is a document that the courts do commonly refer to in order to identify issues of scope, identify whether there's any risks of matters proceeding without any sufficient notice to the public and the overall grand concept of natural justice. So I would highlight as examples the summary and the summary of submission points S146.052, point 057 and point 059. So we're all familiar with these tables. It refers to the plan section, it refers to the provision. It then includes a column for position. So one of these positions records support but seek further provisions. Then there's the reasons column, and then there's the decision requested. Now, under the decision requested, the Southland District Council decision requested on submission point, sorry, I didn't note this one, point 051, is move this policy to the natural character chapter with a specific objective for restoration and or enhancement to fully support the policy. So that's directly under a heading in the table saying decision requested. So in my submission, there is full public notice through the submission, through the notified plan, but also through this document, which gives the public a summary of what decisions are requested. There are quite a few decision points that are noted in that summary, so I apologise if I have missed the numbers, and my preparations today, it has been a little bit last minute. So those are my submissions in terms of this process. The only other point that I would wish to note is the legal point I made last week in relation to Albany North. Ms Cook-Munro has not provided any basis why the panel shouldn't take due account of the High Court authority, which, as we've previously discussed, is a stronger authority than some of the other cases that she has referred to. Thank you.
All right, is there any questions from the panel in relation to that? No, no.
No, thank you.
Thank you for that. That then brings us to the end of the presentation from Federated Farmers. So thank you for your attendance, for your input. You've raised what is a meaty issue for the panel to consider, and we will do so with an open mind and due consideration of all that we've received. So I will adjourn the hearing now for 15 minutes, and on our return we will start our questioning of the Section 42A author for the hearing relating to ecosystems and natural biodiversity. Thank you.
Okay, thank you so much for having us.
Sorry, just to interrupt, panel, I'm assuming that you don't need anything from me today?
No, we don't need anything from you today, and if we do require some feedback on what's been presented in the evidence, we will issue a minute asking for that. Otherwise, we'll get the admin team to pass a message on to you.
Lovely, thank you.
Thank you. We're adjourned.